I mean, I mean, this is really embarrassing. I just did the whole intro, and you mean to tell me I was not even streaming? I literally just talked through. I have to do it again. I did a special funny thing and every. Oh my god, ladies and gentlemen, this is what I get for trying to be fun. Oh, of course.
The after joint dancing on the people dancing on the people. I got people on the people.
Okay. That's just it's just not it's not gonna oh god. Ladies and gentlemen, do you have purple hat cheetah prince dancing on the people at the after joint dancing on the no you do not. But you do have well, you've got the court gallery live now. A few minutes late, but it is live now. Yeah. I just don't know. I just went through all this. I don't really. I swear you all heard it. I know for a fact that I looked down and realized that I just clicked manage stream and I didn't actually click start stream. But I've already walked through all of this material with you once. It's in the description. If you're interested in what's going to happen during the show, it's in the description as always. Check it out. Time codes and everything. But I will walk you through a little bit of the docket. We're going to start with Judge McNally. He's not Judge Daddy. He is Judge Dad, and he is dadgum disappointed tonight, ladies and gentlemen. It's been a long week for Judge Dad, and I got a feel for him. He has one exceptionally stupid individual who he deals with today. You may have seen it, you may have not. But we have some side quests to check out. Before we get to that point in the show, ladies and gentlemen, after we deal with Judge McNally, we're going to hang out with Judge Simpson, who, just like Judge DeSanto, had a myriad of mad cases, one right after the other. So this is a classic compilation tonight, ladies and gentlemen. I'm bringing you a little bit of all of it. Left field, right field, it's all here, and it's all a little bit weird and a good bit crazy. More than anything, it all starts right now. No, really, it does. See, the first time I did this, I had the timing down it was perfect the first time I did it. God.
Shauna Rochelle Curtis 26T6475004A and B. Could I have Zuko seated at the table here, my right, your left? And you can come up here, Ms. Curtis. Your name? Nice and loud for me. You're charged with driving on a suspended and defective equipment. You have the right to an attorney. If you want one, I will give you one. Would you like a lawyer?
No.
I'll arraign you and then I'll send you to the prosecutor. I'm going to need that one sentencing with Mr. Gamber. You're charged with
Miss Curtis up here, Tashada Curtis.
What's that?
Is this Tashada Curtis? I'm sorry that you have at the podium.
Yeah.
She has 2 warrants that we're working on right now also.
All right.
And I believe it does look like though they are Judge Heston, so I'm not sure if you just want to send her over there or when we're done with them. But just to give you a heads up.
All right, thank you. Ms. Curtis, you're charged with operating a motor vehicle on January 18 of 26 in the city of Trenton on Fortner West at 1:16 in the morning. They think you had defective equipment and a suspended license. That is a misdemeanor driving on a suspended, punishable by up to $500 in fines, 93 days jail, costs or all of those penalties. Do you understand that? Nice and loud.
Yeah.
Did you sign the advice of rights and read and understand the rights? If you plead guilty, you'll be giving up all those rights and we're not going to have a trial of any kind. You understand that? Yep. You still wish to waive your right to a lawyer? I'll enter a not guilty plea. You got to show up in court. Why? When was she scheduled for court that she failed to appear on?
October 12th of 2022.
Oh, geez, I don't want to rush you here. What are you doing?
Fail court order.
Here, this place. You were supposed to be here in October of 22. Well, don't sound so aloof about it, okay? You're not endearing yourself to any judge when you pull that kind of nonsense. You're going to be arraigned on those warrants next door. $500 personal bond. You're lucky you're getting a personal bond. Do you work? What are you acting like this for? Like I don't recall, like it's not a big deal. Like I forgot to pay my water bill that was $3.13. Young lady, don't play games. Judges don't like games. You want to play games? Go to the store, buy Scramble or Trouble or Monopoly or whatever else. Don't play games in here. You got it? Good. You'll go meet with the prosecutor. Either way, you'll come back in front of me, and then you have to go next door to Judge Hessen, and she will arraign you on those charges when they cancel the warrants. Good luck. Tina Wilson. Tina Marie Wilson, 25G, 82771A and B. You can have a seat there if you'd like, ma'am. Is that a cup of water or what is that? Well, I don't want you to vomit.
Me neither.
Geez, oh Pete, relax. Take a deep breath and sit down.
Good morning, Your Honor. Attorney Corey Westmoreland appearing on behalf of Ms. Wilson.
Now I know why you think you might vomit. You haven't been here in 6 months. How come?
I'm very sick.
Okay, I'm sorry about that. Okay, so you pre-tried this, right?
That's correct, Your Honor.
Let me just figure out what we've got. We got an abandoned vehicle charge. What is this? It was property maintenance, abandoned vehicle on street. Okay. So she owes on that and she's going to plead to the civil infraction of loitering, right?
That's correct.
All right. So she's going to plead to loitering. They're going to dismiss the original charge on file A, and then she's going to plead. She's got the default judgment on the other case, right?
Correct, Judge.
Ma'am, you want to plead to loitering? Your lawyer did a good job for you. You want to plead to loitering? It's a civil infraction. You can't go to the charge of loitering, responsible or not responsible.
Responsible.
$150. Property maintenance charge is dismissed. So you owe $150 plus you owe the $213, I believe I saw, right?
I believe that was it, Judge. I'm looking real quick to double check it on that.
I thought I saw 213.
It is 213.
So you owe $363. Can you pay all this?
She's able to pay $100 today, and she would need a payment plan due to her health. She's unable to work, so she's.
Are you on disability?
No,
No.
she needs to be. Absolutely.
I signed up for it. It's in process.
Okay, all right. All right, so on the loitering charge, let's do the abandoned vehicle. Who's this with you?
My name.
Her next door neighbor says, "Oh,
Well, that's nice. We all need good neighbors like that.
Yes.
All right. Is there a way you can come up with a little more, like $40 more on top of the 100? You pay one. He's shaking his head. Yes. Do you want to confirm that with him?
they're able to."
He wants my money for me.
You pay $140 today on the abandoned vehicle, and I'll waive the balance on that. Okay.
Thank you.
And you'll still owe $150, and I'm just going to give you On the civil infraction charge, I'll just give you until April 1st to pay that. Can you do that?
Sure.
They'll make it.
And if you can't pay by then, you call the court, we'll go on Zoom, I'll give you an extension. Just don't ignore me. I wish you well. You're fine. See, it wasn't so bad. You didn't throw up or anything. Good luck.
Thanks.
Good
Have a
luck.
nice morning.
Thanks, you too.
Couldn't move fast enough to get to the bathroom, so I brought it up.
All right, you're fine. Relax. All right. Tashana Rochelle Curtis, 26T 647 504A and B. Your name, ma'am?
Sean Curtis.
All right, nice and loud. You're going to plead to no operator's license on person, right? They're going to dismiss the driving on a suspended, true? If you do that, the possible penalties are up to 100 fines, 90 days jail, costs, or all those. Do you understand that? And again, did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial or a hearing. Do you understand that? You have the right to a lawyer. Do you still wish to waive your right to a lawyer? Just keep your voice up for me, okay? To the charge, no valid operator's license on person. How do you plead?
Guilty.
Were you operating a motor vehicle January 18 of 26 in the city of Trenton, county of Wayne on Fortin or West at 1:16 in the morning? Did you have a valid license on your person? Are you on probation or parole?
No.
Anybody forced you to plead guilty?
No.
Please accept that the no ops, the suspends, dismissed. I'm ready to sentence you. You ready? Anything you'd like to say? You got to stop doing it. And then you don't show up and you go out and got another one apparently. 100 fines, 70 costs, 75 victims' rights, $50 justice assessment, 295 or 60 days. You can go down the hall and pay that, okay? And you have that to pay, correct?
Yes.
All right. And by the way, did he address the defective equipment? Oh, and I'm also dismissing the defective equipment too. So you can go down the hall, pay your 295, and then go in front of Judge Hessen, okay? Good luck. Susowitz, Brian Susowitz.
Yeah.
This is 25F243700. Does he really want to do this under is this under 779?
I don't believe so.
He just put it under that.
If he did, it's fine with me.
I mean, the guy just was in jail for 93 days. I mean, it's a noise violation. I mean, if you think you want, I would just give him fines and costs. He's got a heck of a record. If he was going to go to become a priest or something, I would, you know what I mean?
Yes.
He just wrote it in this line that he usually checks a box for statute. He didn't do that. Noise violation.
That's what he proposed to me, that he had to plead guilty as charged. And,
But, recommend fines and costs.
recommend fines and costs.
I'm fine with that.
Sir?
But we're not gonna fool around with 771, right?
No, I wasn't even aware of that.
Okay, good enough. So do you understand? State your name. Do you understand what your lawyer just said? So first of all, I guess I gotta have him, he's gonna stay in mute, wait formal reading for arraignment purposes.
He will, Your Honor.
And then he's going to plead guilty to a noise violation with the prosecutor recommending fines and costs only, right?
Yes.
Is that what you want to do?
Yes.
That is punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that? And did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes, sir.
To the charge of noise violation, how do you plead? Were you at Walnut Creek Drive, 28227 Walnut Creek Drive, Flat Rock, April 4, 25 at 3:54 in the morning? Were you yelling? Were you yelling racial slurs?
I might have, I was John.
Why would you be yelling racial slurs? I'm sorry?
Not sure.
I hate that. I always think when somebody, is making slurs about anybody, they must be emperor of the planet or something. You know what I mean? Like, who are they? I hate that.
Unfortunately, alcohol can fuel a lot.
Yeah, I know,
Discussed that with-
but we don't usually say things unless we feel like them, whether we're drunk or not. That's my issue with it. All right, I'll accept the plea. I'll go along with this fines and costs, but you're gonna pay some fines and costs. Anything?
Yes, Your Honor, he is working, but he does have some obligation, Your Honor. He has a family that he supports and, some other bills as well. So this is not a violent offense, fortunately.
I know.
So I'm asking for a minimal amount of fine.
I just don't like these. I just don't understand it. Anything you want to say?
I was in a bad state of mind. Wasn't living how I was supposed to live. It's not an excuse. I understand that. But
Your record is horrible.
I know I'm trying to turn it around. I got a daughter now. I got another way.
I just don't, there's no place for racism in our society. Don't people think it's cute? I find it disgusting. 200 fines, 225 costs, 75 victims' rights, $50 justice assessment, 550 or 90 days. I'll let you pay this at the rate of 50 per week. And you can start to pay this beginning on February the 27th. If you need more time, you come talk to me. Don't be doing that. Good luck. Thank you.
Judge, he does need to go over to Judge Hesson's now. He has a
Need
case
to go
over
to
there.
Judge
too.
Heston's too. Come on back. Let me do your bond violation and then we'll get prosecutor in here. Summer Lori Greathouse, 25F 245 336. Good.
Judge.
Your name?
Elizabeth Laws, probationary.
Raise your right hand. You solemnly swear affirmative penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
I do, Your Honor. I just passed up to you, because there are numerous, violations, numerous positive blows on Soberlink, so I just, that way, you have that in writing.
This is the one with the fourth offense.
That is correct, Your Honor.
And are you adopting this? You've got a document that says, and I can read them real quick. She was positive for alcohol in the Soberlink on February 8 at 7:27 p.m. She was positive and with these numbers corresponding on this document.
Correct, Your Honor.
February 9th at 11 a.m., 11:17, 11:34, 11:53 a.m., 3:26, 3:44, 7:22, 7:40, 7:57, 11:22, 11:39 p.m. Also on February 10 at 11:27 and 11:44 a.m. Also on February 10 at 3:27, 3:44, 4:02, 4:19, 4:37, 7:29, and 11:18 p.m. And then again on February 11 at 11:25, 11:43, 12:02, 7:11, and 11 p.m. She failed the blow, right?
That is correct, Your Honor.
This is the document you prepared?
That is correct.
Sign it, will you, for me, please? I'm gonna find that there's been a violation of defendant's, defendant has violated bond conditions. I want you to go into Mr. Longton's office. I want you to tell him I'd like him and his client to appear here if he's available this ASAP this morning,
Yes, Your Honor, in person?
in person. I'm issuing a bench warrant, revoking the release, forfeiting her bond, and issuing a bench warrant pending a hearing. The bench warrant will be in the amount of 10,000, 10%. Boy, this is not good. Thank you. All right, so we're gonna go on record on this. Summer, Lori, Greathouse, P5F 245 336. So if we haven't put the warrant in the lien yet, Heather, don't. Good morning, Mr. Longton, or afternoon. Your appearance?
I'll call out your honor, so.
Your name, ma'am?
Summer Greathouse.
There's a multitude of probation violations or bond condition violations that are alleged. February 8th, all day on the 9th. I'll be happy to give these to you.
So,
The 10th, all day, from 11/27, the 11th. So I'm going to hand you this, Mr. Longton. You can look at it. I'm going to conduct a hearing. She can either plead guilty or we can have a hearing as to whether or not she violated the bond conditions. So we'll go off the record. I'll let you two talk and,
Not necessary.
okay.
I already discussed this with her and if they're not guilty, I explained to the court why.
No, that's okay. We'll have a hearing right now.
Right.
But I'm gonna, Ms. Wild, your name?
Elizabeth West, Your Honor.
Okay, so Mr. Longton's advised that she is going to plead not guilty. So are you ready to proceed with the hearing?
I am, Your Honor, as well as the Soberlink expert with house arrest services. I told him that if he was needed, I would be able to email or call him and he would be happy to be here present as well.
She still wants us to do that?
Yeah,
If she does, that's fine.
She does.
Okay, call and get them ready, and then we'll start the hearing. Why don't you make an extra copy of that?
I did, just to be on the safe
So
side.
I'll take the one, the original there that I gave to Mr. Longton. And we'll go off the record while you called him. Are we all set?
He said he'll be joining momentarily. He already has your Zoom information. It was just a matter of him, I think, polishing up with what he had in front of him and.
Let's go back on record here.
Right on Zoom.
All right, so I'm recalling Summer Grade House. Mr. Longton's here, Ms. Wiles is here, and Ms. Greathouse is here. So she's pleading not guilty. You can start your testimony. I understand house arrest is going to be zooming in any second, but I'll go ahead and we can start. And then Mr. Longton will have an opportunity to question you. Raise your right hand, please. Do you solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth so help you God?
I do.
Okay.
Sure. On February 5th, Ms. Greathouse was referred to house arrest services to obtain her Soberlink device, which she did do in a timely fashion. I was notified on February 8th that Ms. Greathouse was positive for alcohol at 7:27 p.m.
Yeah.
with a 0.019%.
Wait 1 second. He just told me house arrest is out there. We'll bring him.
Oh.
All right. House arrest services. You can start your video, unmute, and state your name, please. There you go. Thank you. Your name?
Yes. Hi, my name is James Hunt.
Okay. The probation director is just beginning her testimony, so we're going to let her conclude, and then we'll go from there. Thank you. Go ahead.
Yes, Your Honor. So again, just briefly, February 5th, Ms. Greathouse was ordered to obtain the Soberlink, which she did. I received an email February 8th indicating that Ms. Greathouse was positive for alcohol, 7:27 p.m. at 0.019%. For counsel and for yourself, Judge, anything below a 0.020% does not require a reblow, and therefore no reblow was required at that time. On the 9th, as listed on the sheet that counsel has been provided, as well as yourself, Your Honor, Mr. Hunt does have this information as well. Beginning at 11 a.m., Ms. Greathouse was positive at a 0.029%. She called house arrest services claiming this was due to brushing her teeth. House arrest services did inform her to continue to blow as required. So at 11:17, she was this is a typo on my part, that was 0.023% at 11:17 a.m., Your Honor, again, my typo. At 11:34 a.m., she was 0.23, 11:53 a.m., 0.017, again, under that cutoff, no more reblows were required, but resumed to be positive at 3:26 p.m. at 0.020, 3:44 at 0.013, under that cutoff, no further blows required. Continued to be positive that day, 7:22 p.m. at 0.023%, 7:40 at 0.022, 7:57 at 0.019 under the cutoff. Continued to be positive that day at 11:22 p.m. at 0.025%, and 11:39 p.m. at 0.018% under that cutoff. Then on the next day, February 10th, she was negative for her morning blow. However, resumed being positive at 11:27 a.m. at 0.023, 11:44, 0.017% under that cutoff. Continued to be positive that day, 3:27 p.m. at 0.040%, at 3:44, 0.033%, at 4:02 p.m. 0.027%, 4:19 p.m. 0.021%, at 4:37 p.m. 0.016 under that cutoff. She did continue to be positive for alcohol, however, again, under the cutoff at 7:29 p.m. and 11:18 p.m. The following day, February 11th, she was positive, negative for her morning blow. Positive again, 11:25 a.m. at 0.025%, 11:43 a.m. at 0.021, and at 12:02 p.m. under that cutoff at 0.016. She continued to be positive under that cutoff at 7:11 p.m. at 0.019%, and at 11 p.m. she did fail to blow. An hour and 55 minutes later, at 12:55 a.m., she did blow, and she was all zeros on her late blow from 11 p.m. Last night. In the meantime, she did call house arrest services, and she claimed that her device was malfunctioning because it was requiring her to continue to blow. House arrest services did inform her that as long as it told her to reblow, that she needed to. This is what happens when we're positive for alcohol. It's going to have you blow until you are under that cutoff to ensure that it isn't environmentals like toothpaste and all the other excuses that sometimes we hear. But the one excuse that Miss Greathouse used while brushing her teeth back on February 9th. I did ask them to send over her contract as well that she signs with them that indicates that she agrees to wait at least 20 minutes after using any mouthwash or any product containing alcohol, such as, but not limited to, hand sanitizer or any other topical substances that may include alcohol like cologne, perfume, bug spray, before she submits a test, as well as she agreed to submit to required tests if requested by the device after a sample had been submitted. There is no issue with Ms. Greathouse continuing to blow, but again, it's not a malfunction of the device. Mr. Hunt here is to do his testimony. It's because of the detected use of alcohol that she had to continue to blow, Your Honor.
Okay, do you have any questions of Ms. Wiles?
Do I?
No, you're a lawyer.
Ma'am, you're not technically prepared to testify reliable this device is, correct?
I would leave that up to Mr. Hunt, sir.
The answer is no. You're not totally qualified. My questions are Mr. Hunt.
Okay. Mr. Hunt, I'm going to ask you to raise your right hand, please. You solemnly swear or affirm the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
Do you want to ask him some questions?
I'm going to ask him just a brief question in relation to an email, and then I'm happy with Mr. Longton, of course, to ask Mr. Hunt any questions. Mr. Hunt, you and I had talked on the phone. I asked you to review those blows from Mrs. Greathouse in reference to the possibility of that device being defective. And you indicated to me that as a knee-jerk reaction, you did feel that it could be a malfunction of the device, but that you wanted time to look at those blows and make, of course, a more professional decision. And you indicated to me in the email, I'm going to ask you if this is correct, that in looking at each single event, these are consistent with drinking. Is that correct?
That is correct, yes.
Thank you. No other questions, Your Honor.
All right. Do you have any questions of him?
Mr. Hunt. When my client calls Soberlink to complain about the device, does she talk to you or to someone else?
She would have spoke to somebody in the monitoring center.
Who would she have spoken?
I would have to pull some calls to get names. I do have a note in here from Miss Hall, one of our monitoring room employees.
And that note says what?
That she called and stated the device keeps telling her to take to test multiple times. We advise her to just keep testing when the device says to. She stated that it may be because she smokes cigarettes. We advised her to reach out to her officer if she has any questions about the report.
What else do you have in your notes?
I have another note in here from a Miss May that says that the client called and stated she brushed her teeth and then left the house and tested on her device.
Do you have any other?
Those are the two notes on her account.
Do you have any notes from your staff indicating that they spoke to her about having the device recalibrated?
I do not know.
How often do these devices need to be recalibrated?
The devices are recalibrated after 1,500 tests have been taken. This device, I'm still waiting to hear back from the manufacturer because this was kind of short notice. But this device has, as of right now, 1,448 tests remaining until calibration, which indicates to me that the device was recently calibrated before given to Miss Greathouse.
Isn't it true that these devices sometimes fail before reading 1,500 tests?
It's technology, so yes, that's certainly possible.
Isn't it true that it has happened and you have a record of these devices failing?
Yes.
So you don't know whether these test results are accurate or not.
But I mean,
You don't.
no, I do not. No.
Got nothing further to see.
Do you have any other questions?
Nothing further, Your Honor. Mr. Hunt, is it possible to send a device into the manufacturer to determine in this circumstance if this is a device failure or not? Would there be a definitive answer?
Yes, absolutely.
Thank you.
Well, Mr. Hunt, the question is, if you send it back to the manufacturer, can they tell definitively whether or not it has been failed? Are you technically an expert that you could tell us if that's true or false? That the manufacturer can tell us definitively whether or not it's been failing?
I would be able to recite the report that was given, but no, I'm not an expert in device calibration. No.
So we don't know whether or not the manufacturer's report would be definitive or not, do we?
We don't even have that report yet to determine if it's definitive.
I'm sorry, guys, this is just totally Prosecutor.
Wait a minute. I want to interject.
That I wasn't done.
Yeah, let her finish first. Go ahead. You want to ask a question?
Yeah, I had a follow-up question to that, but
go ahead.
Mr. Longton chimed in. Mr. Hunt, and it actually alluded to what Mr. Longton was. So if we send that device in and the manufacturer reviews the device and we get that report back, that then, piggybacking off Mr. Longton's question, then being the expert, because that is their device, would we know if it malfunctioned or not?
Yes, correct.
Thank you. And I am done now.
And read the conclusion that he drew in the email again. Will you do that for me, please?
I can actually read that in whole. It says, good morning, Ms. Wilds. As we discussed on the phone, I went ahead and did some math to figure elimination rates. And these events are consistent with consumption. I have a consolidated report attached, and I also have a detailed report covering her positive dates from 2/9 to today. Knee-jerk reaction, seeing the mix of positive and compliant, was device failure, but looking at each as a single event, these are consistent with drinking. If you have any questions, please let me know. And it is signed by Mr. Hunt.
All right. Do you have other questions?
I have none. I have my confidence. That's it.
Okay. Raise your right hand, ma'am. Solemnly swear affirm under penalties of perjury the testimony you give in these proceedings will be the whole true self you got. Okay, go ahead.
So what happened during the earliest possible?
I'm sorry, I didn't hear the question.
What happened with Soberlink starting with these early possible days like February? What happened?
On the night, so I had taken a couple of days off since the last time I was in court and I stayed home. And then I went back to work that Tuesday, I believe, and I'm in my car a lot. So when I left this morning,
Wait a minute. Which morning are you talking about?
The 9th, I believe that was Tuesday.
Well, the first one said she was positive for alcohol at 7:27 PM on February 8th.
Talk about that.
8th. What day of the week was that?
February 8th would have been a Sunday.
Honestly, Sunday I was at home with my kids. We played some games, had the football game on. I got them to bed because I had school the next day. And then, so it must have been Monday then.
February 8th is the thing.
Okay, so then starting that Monday, I had gone back to work, back into the office, driving around throughout the
So the
day.
question is, what happened on February 8th at 7:27 PM?
I have no idea. You know, I didn't ask, I don't remember that it asked me to retest. Honestly, that was on Sunday. I don't remember.
Go ahead. On the 9th, you went to work. What time did you go to work?
I left my house at about 10:45.
Okay. Where do you work at?
The office is in Allen Park, but I drive clients around or meet them at different houses. I do real estate.
Okay, so
So on Monday, I had a client that, well, I went to the office first. We had an 11 o'clock Zoom. I did the Zoom and then I left. I met up with the client, so I did a bit of driving around. When I had gotten the first one, I brushed my teeth, left the house. I do smoke cigarettes, so when I called, I didn't claim that it was because of brushing my teeth. From my recollection, that was the first time it had asked me to retest. So when it happened, I called right away and asked about it.
Who?
I called house arrest. And I said, this is asking me to retest. And so I had asked questions the day when I signed the paperwork, when I got the device, and like Ms. Wilds had explained, like they did kind of go over everything. That was the day that I was in court. Did I necessarily remember the 15 minutes before and all of that stuff? No, yes, I did sign it. There was a lot going on. It was high stress, high anxiety. She went over it.
Let's keep.
Okay, so this day, all day I was driving around clients and I picked my kids up at this 3:26 time. I was with my kids. We went home, we had dinner. That was on Monday. They didn't have any sports that evening.
When is the last time you consumed fentanyl? Is it before February 8th, 26?
It was. Yes, it was in December.
Last time you consumed it?
Yes, sir.
Did you consume alcohol on February 9th any time?
No, sir.
So on your device, when you blew at 326 and 344, did you see these readings on your device?
No, sir.
You don't see these readings?
No, sir.
They don't. And okay, so you just
So I
said
did a
it.
retest. No, sir.
And when you're asked to reblow,
Yes, sir.
when were you asked to reblow?
Tells you to wait 15 minutes.
Right, so on February 9th, how many times were you asked to reblow?
The 9th. Felt like every time I did it, that's why I called. And then I wasn't asked to reblow on the 10th in the morning. And I
let's
think
stick with the 9th.
Okay, so every time, and I had called that day and I called house arrest. And I said, it keeps asking me to reblow. What could the reason be? She said I could bring it in and have it recalibrated. And then I had.
Okay, go ahead. I'm sorry.
So then the next test, I believe, did not ask me to reblow. And then the one in the evening, I think did ask me to reblow. And then the next day, it didn't in the morning. And then it did a couple of times throughout the day. I think that one was the day that it asked me multiple times or maybe not.
Let me ask you a question.
Yes, sir.
I ordered you to go and get the Soberlink the day you were in court. That's February 5th, right?
Yes, sir.
Did you go on the 5th?
Yes, sir.
Did you have any problems when you blew into the machine on the 5th after you acquired it?
The first machine they gave me was not working, so she gave me a second one and then
Before you left?
no.
Wait a minute, slow down. Let's slow down. You went over to house arrest on the 5th
Yes, sir.
in Livonia.
Warren.
Warren, I'm sorry. Warren,
Yes, sir.
you said she replaced the machine?
The first one she gave me was not working.
And did she replace the machine before you left house arrest?
Yes, sir.
Okay, so you went back from house arrest on the 5th, right? With a workable machine, at least in your mind.
Yes, sir.
Did you have any problem when you blew in that machine on the 5th?
No.
Did you have any problem when you blew in that machine on the 6th?
On this, I don't remember if it was.
Well, let's wait. Let's not guess. The 8th was Sunday.
Yes, sir.
The 5th would have been Thursday.
Yes, sir.
You got the machine on the 3rd, on Thursday, the 5th.
Yes, sir.
You didn't have any positive blows with it on the 6th, right? You didn't have any positive blows with it on the 7th. Wait, let me finish. You didn't have any positive blows on that machine on the 7th, did you?
No, sir.
And when you woke up in the morning, when is the first time you tested on the 8th?
Would have been between 6:45 and 7.
Did you have any positive blow on that time, on that occasion? Well, any problem with the machine testing inappropriately until at least 11 o'clock on or about the 9th of February.
It was the 8th.
Okay, you're right.
The only issue.
Wait a minute, slow down, my mistake. On the 8th, you blew positive at 7:27 p.m., right?
Yes, sir.
How many times did you test it on the 8th prior to the 7:27 positive blow?
I tested 3 times.
Any problems with those results when you blew on the 8th prior to the 7:27
No, sir.
blow? Any problem with the machine when you blew on the 7th?
Not with a retest. The only issue I had with the machine that Saturday was that it wasn't turning on. And when it finally did power on, it had battery. So it wasn't that the battery was dead. That was kind of when it's. I didn't think much of it.
Any positive blow on the 7th? I'm asking you.
Oh,
Any positive blow on the 6th? Okay. Anybody have any other questions on it? Go ahead.
Your testimony been completely candid?
You got to keep your voice up for me, though.
up.
Yes.
When you heard, has your testimony been completely candid?
Yes, sir.
Last time you had a drink was in December.
Yes, sir.
You willing to take the polygraph?
Yeah, we do.
They're much more reliable than they were when you and I started practice law. And Taylor Police Department has a polygraph, and they're more than happy to pay for the polygraph. Because otherwise, you're going to make a decision based on a device that could well be defective.
It could be, and if I am not satisfied by preponderance of the evidence that she consumed alcohol, I'm going to find her not guilty. No, wait, just wait. Let's not, I don't want to talk about polygraphs. You ask your next question. Mr. Hunt, I want to ask you one while he's thinking.
Yes, Your Honor.
I want to make sure I understand. You said maybe every 1,500 blows, it has to be recalibrated. Right?
After 1,500 blows, yes, it's due for recalibration.
You said this particular machine, based on your inspection, still had roughly, I think you said, I want to double check, 1,444 blows left.
1448.
1,448 blows until the machine needed to be recalibrated.
Correct, yes.
Go ahead.
Mr. Hunt,
Yes.
last year in 2025, were there machineries that turned out to be defective before there were 1,500 blows?
I'm sorry, can you say that again?
Last year, January through December of 2025, were there devices that turned out to be defective and needed calibration before 1,500 blows?
Yeah, it's technology. Things can fail. That's absolutely true.
And you had devices that did fit, correct?
Yes.
DNA open today?
But on-site is, yeah.
Good.
Yeah.
What else?
Your Honor, I have the greatest confidence in my client that she's telling me the absolute truth. I think it would be a horrendous miscarriage of justice to have her killed based on what you've heard today from both her and Mr. Hunt. And I know you don't want to hear anything about polygraphs. I understand why the District Court of Appeals is clear about that. But in all honesty, when you and I practiced law, they were only 60% effective. Today, they're 98% effective. I'm more than happy to have her polygraph. That's a Taylor PD.
How do you explain the fact that this machine was working on the 5th, was working on the 6th, was working on the 7th, and worked until 7:28 or 27 properly on the 8th, and then all of a sudden she starts blowing positive, and now there's a problem with the machine?
And we don't have the testimony from the factory to answer that question as to whether it worked properly today, failed tomorrow, and worked properly 2 days later. We don't have that kind of technical testimony. Mr. Hunt's already testified he relies on the factory for that kind of. When I told my car this afternoon to come here, my brand new Jeep would not start. I had to go back in, call the dealer, come back out. Eventually, it started. Who knows why? They don't know why. Who knows why, whether or not this thing fails every other day or failed all these times. We don't have the technical testimony from the factory. I don't have it.
I don't, this is not, we deal with these machines all the time, Mr. Longton. Soberlink devices are accurate. Once out of every 500 defendants will somehow, some way, when they get results like this, want to try to insist that there's something wrong with the machine. There's nothing wrong with this machine. They don't need to prove beyond a shadow of any doubt that the machine is working accurately. It's pretty evident here. He told you what it needs to have to recalibrate, or how often it needs to be recalibrated. He said it still had 1,448 blows left. It's clear it was working on the 5th, the 6th, the 7th. And based on these results, when you take them, I've got testimony from Mr. Hunt that it's consistent that the amounts would reduce like this. Yes, listen. I don't think there's any question in my mind that she was drinking. Okay? I get this all the time. And there's no question in my mind that she was drinking. And I'm not going to order a polygraph. I'm not sure I don't want to send her for a test. But I'll tell you what, I'll send her for a test.
If she flunks, put her in jail. Because I'm confident she's not drinking.
If she flunks on this test, I will put her in jail, and she will remain in jail. I will set a bond she won't be able to set, because I've just done, in my view, as I believe now, I've had somebody commit perjury in this courthouse, and I don't think very kindly of that. So yes, let's have her go to on-site today.
Yes.
Now, I am not going to be here tomorrow, but I will be more than willing to Zoom tomorrow. And we can Zoom on this case at 9:30 in the morning or 10 o'clock in the morning. You available, Mr. Longton?
I will change my schedule.
We'll Zoom on this case at 10 o'clock.
What I could do is I can have them send it straight to the lab. It won't be a screen, which would probably be more preferable. I assume Mr. Longton would prefer that as well, since he wants the actual results. So she can submit to her test today at 4 p.m. on site, and they can actually send it to the lab. Now, those results won't be back tomorrow. Should be back Monday or Tuesday. Court's closed
What
Monday.
does trouble me, though, is Yeah, let's do that. I'll do that. We'll continue the hearing at 10 o'clock. Now, I'm going to give you one last opportunity.
Yes.
I'm going to let you go test. If that test comes back positive, as opposed to me finding you guilty right now, I'm going to set a bond you will not be able to make. Do we understand? Maybe you need to go confer with your lawyer. I've been doing this a long time, young lady. I can tell who's telling me the truth or not. I don't pretend to have every answer, but I'll tell you what, I'll compare my ability to determine somebody's credibility with anybody's. And I don't believe for 1/2 a second that you're telling me the truth. And then if you go and test and I have confirmation that you've committed perjury in here, you are going to have a massive problem with me. It's going to be so big of a problem, you're not going to want to, you're not going to believe how bad it's going to be. So I think before I send you for that test at onsite, you need to go confer with your lawyer for a few minutes. And after you confer with your lawyer for a few minutes, if you two want me to still order you to go to onsite, I'll order you to go to onsite. But do this, listen, don't talk to him now in front of me. Go take a few minutes. But think very carefully about what you're about to get into, okay? Do we fully understand one another? Okay, all right. You guys go talk. We can reconvene in here in a few minutes. Thank you.
We all set with Mr. Hunt, Judge.
Mr. Hunt, unless we call you again, thank you very much for your testimony. Mr. Longton, do you need any more
Of course.
from Mr. Hunt?
Your Honor, I only have one question.
Well, I'll tell you what, you go talk to your client and he'll come back in here. Will you zoom back in at 1 o'clock and we'll reconvene at 1?
I sure can. Absolutely.
Perfect. Thank you.
Thank you,
Thank
Judge.
you, Your Honor.
Next, you seated.
Court is back in session.
All right, back on record, getting this files in here. Recalling Summer Lori Greathouse, 25F245-336.
Hold on, Your Honor, what I'm saying, but Your Honor, I'm gonna ask you one of the last times we had it on. She excluded the fact that she's been drinking non-alcoholic beer and thing. And my question for Mr. Hunt would that create a positive test? I don't think it would, if manufacturer's representation as contains is accurate. It's almost 0% alcohol, but I don't know.
We're just gonna follow this little circle around. We're gonna follow the circle around. I just want to know, does she want to get tested?
Yeah.
If she does at 4 o'clock, I'm sending for a test, and we are going to reconvene here at 9:30 or 10 in the morning. If she doesn't, sounds like she's already changing her story. I didn't hear one thing about a non-alcoholic beer until you just mentioned it. Not one, not even close. There's no remote reference to a non-alcoholic beer. So this is what I'm trying to tell you. I don't want to sound like a know-it-all, but I've seen this movie. I've seen this movie thousands of times. And if she wants to go for a test, I don't mind sending her for a test. But I don't hear this nonsense about non-alcoholic beer. Now I'm hearing, Ms. Wiles, you're just walking in, about she's drank some non-alcoholic beer. And would it be positive? So I want Mr. Hunt. I asked Mr. Hunt to show up here at 1 o'clock. And I'm hoping he's going to log in now. Do you see anybody from house arrest out there, Heather?
I do not, Judge.
Do you have your phone, Beth?
I do not, I'm typically not working in court.
So, I just see this perpetual denial. You know,
There is an alternative. That is that she's correct. And
there is an alternative, like there's an alternative that I could pogo stick to the moon too right now. I mean, there's a possibility that some Martian could come grab me. I mean, look, it's fine. We'll send you for the test. I'm only telling you, I have one set of bond in mind. if I don't think that you perjured yourself. And I have another set of bond in mind if I do think you perjured yourself. Okay? And if I send you for a test and it confirms this on top of what I have, I will be 1000% convinced that you perjured yourself. In which case, I'm going to set the bond that I would set if I'm convinced that you perjured yourself. I don't have any problem with you going for a test. You want to go for the test? You go for the test at 4 o'clock. We'll reconvene here at 9:30 or 10. Mr. Hunt, you know, I told him one, I didn't want to have to wait.
Your Honor, may I have another moment with my phone?
Yeah, you can have another moment, but
Your Honor, you've been very clear, so allow me.
I know. I'd like to think I'm clear. Summer, we were back on record, right? Summer Lori Greathouse, 25F 245 336. Okay, everybody's name again. Your name again.
Oh, Your Honor.
Ma'am, your name.
Summer Greathouse.
Elizabeth Probation, Your Honor.
Mr. Hunt. Your name again, Mr. Hunt?
James Hunt.
All right, what is she want to go for the test or what?
Your Honor, can I ask Mr. Hunt just one question?
Sure.
Mr. Hunt,
Yes.
you acknowledge that the device can malfunction one day and function normally the next day. Is that possible?
I have not seen that in my experience, no.
So Your Honor, we're going to change our.
I don't want her to sit here now.
I'm sorry.
So just so you know, I'm going to make the decision because I'm going to spare her the disgrace of just admitting to me under oath that she has committed perjury. I mean, I will do that if you want. I don't want her to plead guilty now when she just testified under oath that she hadn't consumed anything until she came back and said it was non-alcoholic beverage. So if you're telling me she's not going to go for the test, I'm simply going to make my finding right now. And there's no reason for her to change her plea because honestly, I think it's horrible if I'm going to sit here and have somebody admit that they just committed perjury in front of me. So that's what I'm suggesting to you. If you want a different route, you can do that. I get it, Mr. Longton. But I still think, even though I'm upset that somebody would do such a thing, I still have a function here and I'm going to do it to the best of my ability. And that would be my advice to your client. But that's not, she need not take advice from me. So if she wants to just say, if you want to tell me, Judge, we don't see a necessity to go for the test at 4, then I will simply make the findings based on what I've heard here, testimony from your client, from Mr. Hunt, and from Ms. Wiles.
That would be correct, Your
Okay.
Honor. She will not object.
Okay, so I'm going to simply, I'll listen to argument if you want. Do you want to argue or you want me to just make my findings here?
You're fine.
The court finds that the machine was properly working, that the defendant consumed alcohol, and that the document, which Ms. Wild signed February 12, 2026, evidences that intent, or evidences the results. And also, I'm going to find you guilty as charged. Now, you and I are going to have a conversation, young lady. You should have been charged with a felony. You should have been charged with a felony. Now, I don't know why they didn't charge you with a felony. I don't know. I don't care. It's not my business. I just do what they put here in terms of files. Now, in my view, you needed sobriety because I still think we can help you. But if you come in here and you lie to me, there is no way in hell I'm taking you in sobriety court. Excuse my language. I should not have said that word. Ma'am, don't say anything. You should not be saying anything. You are the whopping old age of 8? And this is now your 4th offense. And judges don't like this when you have 4 offenses by the time you're 38. They should have, like I said, charged you with a felony. I'm not being punitive when I do what I'm going to do here, but you're scaring the devil out of me right now. Because when you have a judge tell you not to drink, and you've had 3 offenses, and you've had a Soberlink device, and then you come in and you tell him under oath that you didn't drink alcohol, and he knows that you're lying, I can't help cure somebody who is not going to admit that they are drinking. I get it, that they have an alcohol problem. I get it. There's a form and an element of denial. But honestly and truly, you are going to live a short life if you don't get off of this stuff. It's your life. It's not mine. I have no choice here but to forfeit your bond. I am forfeiting the bond. That means you're losing your $500, and it also means you're going to have to post. And it's a good thing that you guys didn't go for the test just to verify what I was listen to me. What I was 100% sure of, and that is that you had consumed alcohol. I'm forfeiting that bond. I made a mistake when I only gave you a $5,000 bond. Ma'am, I'm going to explain it to you. I gave you a 5,000 10% bond. You know why? Because you told me, as I recall it, you only made about 50,000. Well, that's why I gave 5,000 10%. Because I thought, well, I got to run a Soberlink. She's had 3 priors. Maybe she'll understand that this judge is a little bit serious, but I still cut you a break. And now you go out and you drink again, and you come in here and tell me what I know are lies. 60,000, 10% is the best I'm doing. 60,000, 10%, you're going to have to post $6,000 to secure your release. I have a pretrial date. Make sure any warrant that was entered is canceled. And
If you have to go tomorrow.
I'm sorry, Mr. Longton.
There's no way.
There's no way in heck I'm letting her out. She scares me.
Listen,
Ma'am,
Your Honor, can I
ma'am,
say something?
no. I have made my decision. Listen to me. You are not taking this seriously. You are not. Ma'am, you will not hear me change my mind. I don't decide things over a bowl of Cheerios. I knew if we had a hearing today, you were going to at least have this, because I was sure you were drinking when I talked to you and saw you under oath. You're making your own bed. This is like going to Maui compared to what's going to happen if they turn around and charge you as a felon. I'm telling you, I'm not arguing with you. They'll let you make a couple of calls. I'll move the pretrial date if you want, Mr. Can we do this earlier if she can't post the bond, Miss Heather?
Let me take a look, Judge. The
I'm
Flat
sorry?
Rock case.
Yeah, it's just Flat Rock. I set it for March the 3rd.
Next that we have Flat Rock is next Thursday, the 19th.
I can do the 19th.
Court does call the case People versus Margaret Patowski.
Assistant Public Defender representing Ms. Patowski. Ms. Patowski, would you please state your name for the record?
Margaret Patowski.
Your Honor, I did submit yesterday, late a plea form for
Yes, it was late,
yes, I'm acknowledging.
but I don't.
A plea form for no contest plea for Ms. Patowski. And Ms. Patowski, we went over your rights to a trial, and
I don't have the plea form, so I don't. I have the police report, but I don't.
it was not signed.
That's why. With permission or otherwise, it was not signed. So it wasn't.
So I would like to apologize. Many of these procedures were not procedures a year and a half ago when I was last here. And so I am catching up on the procedures. So I
I understand that, Ms. Gaines.
And I will
I blame that on everybody else that's around you that should have explained it to you.
So if we could pass, if we could pass for a short moment, I know this is very important to Ms. Petoskey. Her outdate has passed.
Okay.
Thank you, and I will get that stopped.
Court recalls the case of People versus Margaret Petoskey.
Joy Gaines, Assistant Public Defender, representing Ms. Petoskey. Thank you, Your Honor, for the moments to get everything in order.
Your name, ma'am? I need her unmuted. Ma'am, can you state your name?
Margaret Petoskey.
Thank you.
Mm-hmm.
I have a plea form before me that indicates that the defendant is going to be pleading no contest to the charge of use of methamphetamine, the 1-year offense. Upon our successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor.
Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Margaret Petoskey.
Okay, you can put your hand down. Ma'am, it is this court's understanding that you're going to plead no contest to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes.
All right. You understand what a no contest plea is?
Yes.
Two things about a no contest plea. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Potential civil liability.
Ma'am, to the charge of use of methamphetamine, how do you plead?
Guilty.
Really?
Oh, no
No
contest.
contest.
No contest. I mean,
Thank you.
I've been trying to get this over with since December 12th. I'm sorry. I'm having a little anxiety right now.
Okay. All right. You understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
All right. You had signed or caused to be signed an advice of rights on your behalf?
Yes,
I hope so.
Well, did
Yeah.
you give your attorney permission to sign the advice of rights?
Yeah.
Okay, after going through that with her?
Yes.
All right. Do you have any questions regarding any of those rights?
No.
You understand that you're giving up all those rights, including your trial rights, which are contained under paragraph 5.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? No.
I was supposed to be released from MDOC on December 2nd, and this is holding me up. So I will be on parole once I get out.
All right, but you are not currently on parole.
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, sir.
All right. Court has been provided and has reviewed Michigan State Police report. I think was the number. Really? I don't need all this stuff. Michigan Department of State Police report for their case number 720724. Any objection to the court having reviewed that report?
No, Your Honor.
Since I'm going to just get rid of this, it's my case anyway. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine defendant's guilt to this offense. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, thank you, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Ma'am, anything you or your counsel want to say before I impose sentence?
Your Honor, Ms. Petoskey does have 62 days of credit as of today, and she has no objection to immediate sentencing and is asking for a sentence to 62 days of credit for time served.
Ma'am, anything you want to say?
Just that you would take that into consideration, please. I have completed everything I needed to do here. I completed my building trades for Vogue Village. While I was waiting to be sentenced with you, I've completed Serve Safe. I just really want to go home.
Understood. The sentence of the court, $125 state minimums, 62 days in jail, credit 62 served. You're all set. Good luck to you, ma'am, when you get out.
Thank you.
Thank you.
Thank you, Your Honor. Good luck, Ms. Petoskey.
Let's call the case People versus Edna Grima. Grima.
Good morning, Honor. Charlotte Steffen on behalf of Ms. Girma. Your Honor, unfortunately, there's been a breakdown in the attorney-client relationship, and I have to ask to withdraw from representation.
Your name?
Edna Girma. May
What?
I be allowed to speak, Your Honor?
Go ahead.
Okay, Your Honor. I couldn't have. Okay. Excuse me.
Bless you.
Thank you. I couldn't have a regular attorney from public defender because it was conflict of interest or whatever. So
Right.
I have from the county, right? Okay. Your Honor, my question is, if I request, if I ask the no probable cause to be handled right here, right?
If you ask for what?
If I ask her,
Okay.
okay, let's just put it like this. She and I were talking and I was stopping her to ask her questions,
Okay.
make sure I'm following her.
Okay.
And she didn't like that.
She didn't like what? That you asked a question?
Yes, sir. She said, if you stop me one more time while I'm talking, then I'm going to get up and leave. Your Honor, I'm 61 years old, okay? I have to ask the question.
So you're going to tell me that Ms. Steffen stopped you without cause to stop you,
What?
was trying to, as she's trying to explain things to you, and that somehow or another that did what to you?
No, what I'm saying is that she was explaining her thoughts on, she was telling me what she was going to do, right? As far as the case. And I was stopping her to make sure I understood what she said. Is what I was doing. She didn't appreciate me stopping her.
Or what she was telling you is, let me get through what I'm going to tell you, and that then I can answer your question.
But I have a hard, I'm trying to follow her as she go along, sir. That's all.
That's what?
I was just trying to follow her. I'm trying to follow her as she goes along, because by the time she gets to the end of what she's saying, I may not remember my question. So if you say, after probable cause, if I ask after probable cause, then what's the next thing? See, first of all, I just want to say, I beg, I pray to God in Jesus' name, and I'm praying right now.
Man, what do you want me to do?
I'm asking you to please forgive me, find grace and forgiveness for me breaking my bond thing. as well as I have a nonprofit youth organization. My nephew was killed in 2021.
Ma'am, right now,
Yeah.
your attorney has said there's been a breakdown in the attorney-client relationship.
I don't understand.
You don't understand that? So you don't, well, you got up there trying to be critical.
I kind of do.
You kind of do what?
Understand it because she and
Do
I.
you want Miss Stephan to represent you or not?
Do I want her to represent me? She don't want to.
I don't think Miss Stephan has ever turned anybody away. You need to listen to her, though.
What did she say?
What do you mean, what did she say? To me?
Yeah.
She just said there's been a breakdown in the relationship, but I'm trying to understand that.
So now what? I'm just confused. I don't understand.
Maybe that's why when your attorney comes to talk to you and she stops you, she's trying to make sure to explain everything to you.
Okay.
Which means you have to listen.
Okay.
So what do you want me to do?
Forgive me for breaking my, do I want her to be my attorney? Is what you
Well, that's where we need to start.
Okay. Do you want to be my attorney? Do you think we can work it out?
Your Honor, with all due respect to the court and Ms. Girma, I do feel bad about this, but I don't think that it's at this point fair to Ms. Girma to have me continue to represent her because in my opinion, it got to such a point that I'm here now asking to withdraw. And Your Honor, I probably have. It's very rare, if ever. So Ms. Girma deserves an attorney that she can effectively communicate with. I'm certainly willing to try, but I just don't think that's in her best interest at this time, Your Honor.
Yes.
So would you please forgive me for breaking the bond thing and please.
Ma'am, I'm not even dealing with the bond. I'm trying to make sure you have an attorney that you're going to listen to and can communicate with. But if Ms. Stephan is coming before this court, I don't think she's ever withdrawn a case before me and asking or believing that she cannot properly represent you. I'm going to take her at her word.
Okay.
So what I'm going to do is we'll need to have, I won't require a written motion, which I normally do to withdraw. I'll take the oral motion to withdraw. It's granted. Ma'am, what I'm going to do is, since I doubt the MAC office knew about it, I'm going to adjourn it out 1 week so that they can have time to appoint counsel to present you. So the probable cause conference will be adjourned to February 19th, 2026, 9 a.m. At this point, your bond was revoked. Your bond will continue as revoked until we can get through everything. So our bond will continue revoked. Thank you.
Thank you, Your Honor.
You get to, yeah. Court calls case of the people versus Marquita Clements.
Mr. Judge, court shall cease to assist the public defender on behalf of Ms. Clements. When you arrive at the point, for the record.
Marquetta Clements.
Marquetta, apologies. Thank you, Judge. Our office has spoken to our client and to the prosecutor on this file. We're going to be requesting a adjournment on this file to try to find a resolution, Your Honor. We can have a couple of weeks, please.
Probable cause conference, February 26, 2026.
Thank you, Judge. I
9 a.m.
know my client also wanted to apologize, Your Honor. I believe last time she was here, there was an outburst with the court, and I know she wanted to take some time and tell Your Honor she was apologetic for how that played out, Your Honor.
I do sincerely apologize. It was out of impulse.
Out of impulse? You need to learn to control that.
Yes, I'm not on my medication right now. I just turned in my Stonecrest papers to the person.
Our fellow. Yes, I believe she had previously requested a bond modification to go into treatment. And I believe she has a job, and I know she would like the court to reconsider her bond request, but she understands in light of how she acted at the last court date the court may not be inclined to do so today.
I am not inclined to do that.
Thank you, Judge.
So our bond will continue as revoked at this point. Thank you.
Couple weeks, okay?
Court calls case People versus Richard Hall.
And on behalf of the people.
Your Honor, Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Hall. Would you please state your name, sir?
Richard Hall.
Your Honor, may we approach?
You in? What are we doing on this case?
Your Honor, we're asking for a preliminary exam.
So your discovery is complete.
That is my understanding. We do have the police report and I do believe there was media in this, and we have that as well.
All right. People have their witnesses available the 24th. Preliminary examination in person, February 24th, 2026 at 9 a.m. before Judge Barr. And as to bond in this case, my understanding, go ahead, Miss.
Your Honor, it came to my attention that the defendant has made 12 calls to the listed number from the victim from other pins. We confirmed that this is her number as I also stumbled upon a text to the victim as well. So this time I'm going to be asking for a phone and text questions to be revoked.
All right. Any response?
No, can I say something? I haven't made no text. She had texted me from a number and I ended up blocking. Yeah, I didn't never text her.
He's saying he is not text.
Pardon?
I haven't texted her. But it was a text that she had sent and I ended up blocking it. I never said nothing to her.
Well, here's what I'm gonna do. Do not text here. There won't be an issue, I don't think. But what I'm gonna do is I'll continue as bond. But at this point, I'm going to revoke his phone and texting privileges. All right, take a closer look at it. All right, thank you. Court calls case People versus Amber Estelle.
Your Honor, on behalf of Mr. Estelle, please approach you. Mrs. Estelle, state your name for the record. Amber Estelle. Estelle. Judge, we're asking for an adjournment. Ms. Estelle is hoping to get accepted into the treatment court in Hillsdale County. So if she's able to get into there, we'd like to see if we could attach this case to that. When is your next court date in Hillsdale?
You've seen the progress report?
I did, Your Honor. Yes, I have my notes for that. We did review it. I've spoken with her. She states that she spoke with Ms. Dozier last night. I think this came in earlier in the day yesterday. She has completed her intake with Hillsdale County. She's since taken 3 tests. They informed Ms. Dozier that they're supposed to be sending the results over to our community corrections.
She has since when taken 3 tests?
From, what is it, the February the 5th date? Is that what, when did you do the intake?
Last intake for Hillsdale County or here? Yes, it would have been Thursday. So Thursday, Friday, and then yesterday.
You
were on my
tested-
screens, yeah.
She says she's tested 3 times with Hillsdale County and they're supposed to be sending the results.
And
over.
what, we don't know the results of that?
She says that they're negative, except
Says
for
they're
the,
negative.
she does, but I don't have the results, obviously. She said that they've supposed to send it to Ms. Dozier. So if we can maybe pass, I can reach out to Ms. Dozier to see if she's received them.
And those are supposed to be all negative.
She says negative, except for Suboxone, which she has a prescription for.
And THC, because that takes more than 30 days to get out of your system. I've only been released for like a week.
Do you have a medical marijuana card?
No.
Are you still smoking marijuana?
No, but this would have been from prior because it takes like 3 to 4 weeks to get out of your system.
Right, but prior you didn't have a medical marijuana card either.
No, but it's illegal.
Really?
In the state of Michigan?
Yeah. I'm shocked.
Okay.
Is that right? It's legal?
Yes.
Yeah.
Yes, Judge, but she does understand while under bond conditions, she is not allowed to use any substance unless they have been.
But she has other cases pending outside of this one. And do those cases let her use THC?
No, Your Honor.
No?
I'd have to look at the
So
dates.
you've been on those cases for more than 30 days?
I have to
No,
look at the
sir.
dates, Your
No?
Honor. to-
No, sir, I got out on bond in Hillsdale County and got sent here and then got out on bond here and started my Hillsdale County. It was all within, it's only been 2 weeks.
All your charges have been 2 weeks
Yes, sir.
for the time of arraignment.
Yes, sir.
Are you just unlucky?
She's
She may?
let me get my computer too, Judge.
Okay, you go ahead and do that. Tell marijuana is legal. Didn't know that. I'm kidding.
Next thing you'll tell me is sports gambling.
I just learned that they call those parlays, Judge. It's a new word.
Why are you gambling on sports?
I don't.
Okay, why are you
I don't have to.
parlaying?
I just learned the phrase and I hear it's a bad thing.
So why are you hanging around people that are parlaying?
You know.
I'm not saying they're not respectable. I just want
I'm trying to be a good influence on people.
You're trying to what?
Be a good influence.
You are?
That's right.
Okay. As opposed to what you've done in the past, right?
That's
okay.
right. Hope for everybody to change.
Still waiting.
I'll just receive drug test results from Hillsdale District dated 2/5/2026 with a positive result for amphetamines, fentanyl, THC, methamphetamines. 2/6/2026 THC prescribed buprenorphine, 2/11/2026 THC prescribed buprenorphine. That was faxed yesterday in this document.
So her next one didn't show fentanyl.
Right, yeah, the first one showed fentanyl, amphetamines, THC, and methamphetamines. On February 6th, the next day was a THC and buprenorphine, which Ms. Dozier notes prescribed buprenorphine. And the same on 2/11 THC and prescribed buprenorphine.
Got it. He just didn't know. Sometimes you're not good, you're just lucky. All right. So you wanted adjournment?
Yes, you're right.
Grant the adjournment.
Thank you, Judge.
Probable cause will be adjourned March 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank
That's
you.
March the 6th, right?
What did I just say? Do you have a calendar? Yeah, look, squint.
You're
Oh,
right.
look at it.
You're right. Yep.
No, I know I'm right. I'm just saying you're not.
It's not the 6th, March the 5th. Bye.
Thank you.
Judge. I'll cry.
All right, let's go on the record in the matter of Michelle Beaumont, 2516664.
Ready, Your Honor. Neil White on behalf of Michelle Beaumont. Please step up and state your name.
Good morning, Michelle Beaumont.
All right, perfect. And today is a date scheduled for probation violation. Your client is on probation for possession of drug paraphernalia. She was sentenced on December 17th of this year under 771.1 status. And it's alleged she failed to appear for drug testing on January 15th and tested positive for cocaine on January 16th. And counsel, as to the probation violation.
My client accepts responsibility. She admits she did not comply and that the facts in the show cause are accurate.
Ma'am, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Are you picking her up, Autumn? Okay. Ma'am, you heard the allegations, correct?
Yeah.
As to those allegations, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand the possible penalty as a result of your plea. You also understand that the recommendation in this matter is for you to continue and complete all terms of probation, revoke under advisement status, pay a $50 probation violation fee, attend outpatient counseling, and 5 days jail suspended. Do you understand that?
Yeah.
I'm sorry?
Yes, I do.
And knowing all of that and knowing that you'll be waiving some of those rights that you've gone over with your attorney, how do you plead?
Guilty.
And you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right. And counsel, if you can please support your client.
Yes, I will. Beaumont, you recall being sentenced in this court by this judge. I believe the offense was possession of paraphernalia. Is that accurate?
Yes.
And as a condition of one of the conditions of your sentence is that you be placed on probation for a period of time. And during that probation, you are to comply with the demand to test for drugs in your system. Is that correct?
Yes.
And that you were notified that you were to test on or about 15th of January this year, and then you failed to appear for that?
Yes.
And then subsequently, I believe the next day, the 16th, you did test and there was a test positive for cocaine.
Yes.
And you don't dispute that you had cocaine in your system that day. Is that correct?
Yes.
Your Honor, are satisfied with that?
All right. The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation, indicate technical violations 1 and 2 will enter. Counsel, as to the recommendation.
Your Honor, with regard to the recommendation, I think most importantly, that you consider not at this point revoking her under advisement status. She's explained to me is that, you know, from what I understand about her, this is a woman she's had struggles. She's still struggling. She's taking steps, and not just because of the court order. She is now back in a program with Pure Psychiatry. That's the facility, correct? You have been undergoing substance abuse therapy.
I start Wednesday.
You start Wednesday, so she signed up for that. She has restarted taking medication, which I think was also set to address some of the struggles that she has and why she obviously relapsed. She's not here to make excuses. You know, it was a snowstorm on the 15th. It's, you know, there's ways she could. She did call. They said, go ahead and test the next day. And there you go. So there's no legitimate excuse for that. She missed. And she accepted responsibility for that. She is employed. She's got a job at the Dollar General on 4th Street. And so she is embarrassed and, you know, again, this is a pattern in her life. She needs to, you know, and she is getting treatment. She is working in a positive direction. This is early. It's only 1 month since she fled. And again, she's embarrassed and she's committed. And we'd ask the court to consider, at least at this stage, don't revoke the under advisement. I think that's a carrot that is important so that she has, you know, depression and yeah. So that's my interpretation. I think beyond that, the recommendations, I think I told you.
All right. So, ma'am, you were sentenced on December 17th. And you had the possession of controlled substance dismissed at your pretrial. And you were sentenced on your drug paraphernalia.
Correct.
And then you did not appear on the 15th. And then you tested positive on the 16th. for cocaine. So I understand that there may be struggles, ma'am, but I need to understand, how does using cocaine help you with those struggles?
It doesn't. What had happened was, I had, a bunch of job applications in, and I had 2 weeks to come up with my court fines and my car insurance. And I just was struggling with, I wasn't on the medication. I was struggling with the loss. The month before was the anniversary of death of my daughter, and I just relapsed because I said, well, what am I gonna do if I don't have money for my car insurance? I can't get to the job and abused and everything like that. So I kind of just self-destructed myself. And then after I talked to my probation officer, then everything started falling in line. One of the job people, general call back, I got a job. I started taking my medications. I started going to doctors. I have, in the middle of getting teeth done, I have tendinitis, and everything's been, I feel so much better now. But I wanted to learn the tools to deal with my situation other than self-destruction, because that's what I usually do.
And so how are you feeling over the last month?
Good, really good. Because even, if I stay up too late or something, can't sleep because of my hands or anything, I feel different the next day. It's not like a groggy, and my anxiety medication or everything is working. So I feel a lot better.
Good. So I think it's important that you remember the difference in how you feel, right?
Yeah.
Because I am hearing that you prefer feeling the way you currently are feeling as opposed to when you're using your cocaine.
Exactly.
Right. Because the cocaine, it's temporary.
And numbing. It's
correct.
Trying to do.
It doesn't alleviate the issues that are occurring. Ma'am, this is your one shot. I will allow you to continue your under advisement status. One more violation and it will be revoked. And you will be serving the jail time that I'm going to suspend. The court's going to order you to continue and complete all terms of probation, revoke your under advisement status. I'm sorry, we're not going to revoke your under advisement status. $50 probation violation fee. You are to attend outpatient counseling, which it sounds as though you've already started to do that.
Yes.
So you can continue that, and then the court's going to order 5 days jail suspended. Mandatory revocation of under advisement and serve 5 days jail minimum if there's another violation. Any questions, ma'am?
No.
Okay, please have a seat over in probation, and then somebody will be with you shortly, okay?
Okay, thank you.
You're welcome. Good luck to you, ma'am. Are on the record in the matter of the state of Michigan versus Pierre Smith, 2644.
Ready, Your Honor. Good morning, Your Honor. Neil LeBlanc here on behalf of Pierre Smith. Mr. Smith, please state your name. Pierre Smith.
All right, thank you. Did that come through? Okay, and do it a little bit more loudly, please.
Pierre Smith.
Perfect. And today is the date scheduled for the arraignment and the pretrial in these matters. And counsel?
Yes, Your Honor. My client waives formal reading and stands admitted to the charge.
The court will waive the formal reading, enter a plea of not guilty for purpose of the arraignment as to the pretrial.
Yes, Your Honor. I reviewed this matter with Mr. Smith, also reviewed with the city attorney. My client is prepared to offer a guilty plea to the amended charge of no operator's license on person. The original offense would be this. I would also point out for the record, I'm going to discuss this matter with the client. Explain to him that there are licensing sanctions which are beyond the control of this court, and we're attorney today. There are no points, but it is referred. So as far as what effect it has on his driving record, that's he understands that that's baked in, and you can't avoid that. I also want to point out to him that we have discussed that he would like to have discovery in this matter. We raised some procedural issues privately with me, explained what could happen if we were to order discovery. There's no penalty, there's no extra cost to do that. But he advised me that knowing that, he's prepared to go forward and accept the plea today to resolve the matter. Is that correct, Mr. Smith?
Yes.
Thank you.
Did that come through, Autumn?
Yeah.
Okay. Sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
And you heard the plea that was placed on the record, correct?
Yes.
As to the amended charge of no operator's license on person, how do you plead? You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights. You understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
And by administrative agency, that could be the Secretary of State.
Yes.
Also, sir, are you on probation or parole anywhere?
Yes.
So that could affect your probation or parole status. Do you understand that?
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, if you can please vote your client.
Yes, Mr. Smith, you recall being, operating a motor vehicle on 4th Street on or about March 17th, 2025?
Yes.
At that time, you had an interaction with a Wyandotte police officer?
Yes.
And during that interaction, you did not have a valid license on your foot, is that correct?
Yes.
All right, I'm satisfied with that.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And as to sentencing, counsel, you asking for immediate sentencing?
Yes.
Okay.
Same, if I could say a few words
Yes.
about Mr. Smith. Mr. Smith is gainfully employed, he's employee of the city of Detroit, as an animal control officer for past 3 years. Is that accurate, sir? Something else I think that I think the court might take interest in his spare time, he's a motivational speaker. He speaks to inner city youth. He has a story I'd like you to hear him telling you about what brought him to that, but he works with a program called Prison Wives Turn to Bosses. Is that correct?
Yes.
Prison wives turn to bosses or lives?
Wives.
Okay.
One, there's an activist who has started a program and he participates in the program. He gets a lot of personal satisfaction out of that. But if the court wants to hear a little bit of the background of what brought him to that, I think it might give you an idea of the character of Mr. Smith.
Okay.
Well, back in 2024, I was shot 5 times by my best friend. When I came home from dialysis in the nursing home, I ran into a lady named Latoya Perry. She told me my story was interesting. She would like for me to follow her and go speak to the youth while she speaks to the older people, the generation that she speaks to. And so since then, I've just been waiting off and I go to different juveniles from Macomb County, St. Clair Shores. This week, I'm supposed to go to Toledo, Ohio. And that's what I just do when I don't work at the animal shelter.
Okay. And sir, how do you get to those places?
Well, she pays for our trips because we all ride on the bus together.
Okay. And at the city of Detroit, or do you work animal control with a partner?
I work for the city of Detroit Animal Control Office.
I understand that. So do you work with a partner or are you on your own?
Yes.
Okay. And what is the message that you give to the youth?
Well, I tell them, back when I was growing up, nobody ever told me, like, what's the last 4 letters of friends? E-N-D-S, all of it comes to an end at some point in time. I always thought, friends is always there forever. I would never tell me, like, when you get older, you gotta wing off and do things your own. You gotta understand that no one's gonna be here with you forever, no matter who they are. It can be, you can know for 20, 30, 40 years. Never know.
Right. Interesting. E-N-D-S. The first 3 letters are F-R-I, which could be fry, right? Sometimes your friends leave you out to fry.
Yeah.
Right? They're not really your friends. So, sir, how long have you been doing that?
I've been home for about 1.5 years now. So I should stay up to it's almost 1 year now.
Okay. And so, why do you keep driving?
Well, I only drove that day because then we had to get a call to a dog was mauling up a child.
So what I do is I decapitate a lot of the dogs, and there's only a few of us there that can do it, and I had to get there so we can decapitate the dog to stick the head out to see if the dog had rabies because the kid had to go to the hospital.
Okay, so why don't you just hop in an Uber or a Lyft?
To be honest, it was a random sitting right there. I didn't think about that. I was just trying to get there the quickest way possible.
I get it, but Uber and Lyft drivers are a dime a dozen in this area because, right, it's a very highly populated area. So you could probably get there and it would have been a lot less expensive, right?
Yeah.
Okay, how'd you get here today? Okay, how much did that cost?
Well, I stay up the street, so it was like $10.
Okay, let's see your app. Pull it up.
But my phone is actually after the charger they put when I leave. I gotta order another Uber to get home. So the phone going to sit by the bathroom.
By the bathroom? You just left it out there unattended?
Yes. I mean, I had to keep it charged so I can get home.
Well, no, I understand, but you would hope that in a courthouse you could trust people that are here, but hopefully. All right, sir. You're not driving anymore? Okay, and you want to get your license back, right? And so what do you need to be able to get your license back?
Well, they told me right now is one that I'm holding up. I had to wait for a court date. And finally, I got a court date today, so now I can step forward to see what else I need to do.
Okay, so you do know that if you want to get your license back at any reasonable time in the future, that you really should refrain from driving,
Yes,
correct?
yes.
Okay. Do you have another case in this court?
Man.
Autumn, can you pull up 25-381, please? I'm just checking something, sir, to make sure that there isn't something that's,
25-381.
yes. Is there not a case number for that? Okay.
No, that's no.
Okay, so there's nothing pending for Mr. Smith. Okay, just want to make sure, because there was another case number on your receipt, sir, and then for your bond, and it was moved to this case, so I just wanted to make sure there wasn't another one that maybe you had forgotten about or something, so. All right, here, sir, I'm going to do you a solid, all right? I'm going to order a $100 fine, crime victim's fee of $75, justice system assessment fee of $50. So that is $225. I'm going to order $25 in cost, so we can apply your bond 100%. You don't have to pay any more money out of pocket. Okay, so I've been told I'm the worst judge in the world. So you're going to see that if you are back here again driving. Got it?
I promise.
Okay. All right. Have a good day, sir. Just stop over at the window in case you have to sign something over, okay?
All right, thank you.
All right, you're welcome. Good luck to you.
Thank you.
All right, and so we are on the record in the matter of the state of Michigan versus Chadwick 2655. Okay, good morning, Mr. Stamper. Okay, you're waiving your right to an attorney?
Yes,
Okay, we have a waiver that we need you to sign, and then we'll call this matter up, okay?
I believe I already signed it.
I don't, oh, let me see here. Oops, yep, it's on the other side, okay. I missed that. No, that's okay. Okay, so, sir, your name for the record, please.
Chadwick Stanton.
Okay, please keep your hands out of your pockets. Today is the date scheduled for your arraignment and pretrial in these matters. And, sir, do you know why you're here? Do you want the court to read the charges, or do you want to waive the formal reading and continue with the proceedings?
You can waive the formal reading.
Okay, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And sir, you had an opportunity to speak to a prosecuting attorney today, correct?
Yeah.
All right, and there seems to be a resolution, correct? Are you picking them up?
Yes.
Okay. And so, sir, what is the nature of that resolution for the record?
The nature of the resolution was that the driving while licensed suspended second offense was going to be dropped, and I was going to plead guilty to the no opt-out person.
Okay. And sir, I am required to inform you, I know that you've reviewed this document and that you've initialed, but I'm required to inform you, sir, that you do have the right to have an attorney represent you in all critical stages of the criminal process. And that this stage is one of those critical processes of the criminal or critical stage of the criminal process. Do you understand that, sir? And you do understand, sir, that if you wanted to have an attorney represent you, you could have one appointed to represent you at no cost. Do you understand that?
Yeah.
And knowing all of that, do you want to continue this process representing yourself?
Yes.
And you did in fact initial this document, correct?
Yeah.
And you read this prior to initialing it. Is that also correct?
Yeah.
Okay, and that document would be 27 District Court, Michigan Indigent Defense Council Program Waiver of Attorney.
Yeah.
Okay, and so, sir, I'm going to have you please raise your right hand. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Okay. And sir, as to the pretrial that you're going to be pleading guilty to no operator's license on person, how do you plead?
Guilty.
And you've gone over your advice of rights, correct? And in fact, you signed that document. Is that also correct?
Yes.
Did you have any questions regarding those rights? You understand by entering into a plea that you'll be waiving some of those rights?
Yeah.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yeah.
Which that administrative agency could be the Secretary of State. Also, are you on probation or parole anywhere, sir? Okay. And so knowing all that, do you want to continue with your plea?
Yeah.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Sir, on the date in question, that being January 8th of 2025, were you in the city of Wyandotte?
Yes.
And you had police contact at some point, correct?
Yes.
And you were operating motor vehicle, is that also correct?
Yes.
And upon request of the police officer at what seems to be a subsequent traffic stop, you were unable to provide a valid operator's license to the officer, correct?
Yeah.
And that was in the city of Wyandotte, is that also correct?
Yes.
All right, the court does find the plea as knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And sir, are you asking for this court to oppose immediate sentencing?
Yeah.
Or do you want to come back for a sentencing date whereby you would have a pre-sentence interview and the court would receive a recommendation from probation?
If we could wrap up this today, I would appreciate it.
Okay, great. What would you like the court to know, sir?
Like that.
Right, about the offense or about you?
What's it?
Okay. Well, sir, what's the status of your license?
It's still suspended.
Okay, why is it suspended?
I have a default judgment that was entered against me back in 2019. And I tried to file a motion to set it aside because
Were you incarcerated in 2019, sir?
Yes.
So you really, I know that you've declined attorney today. However, you really should speak to an attorney because if you were in custody when a default judgment was entered against you, that would be a grounds to set aside the default judgment.
And I'm completely aware of that, Your Honor. And I actually talked to the court administrator at 36, and she's the one that kind of helped me with the process of filing the motion to set it aside. I filed all my documents and everything. I can't pull up the case. It's not pulling up nowhere on the state's case website. I've called the court a couple times. They said that they assigned it to a judge, but they're just like, the judge is waiting for, I don't know what. And
What is the charge in 36 District Court, sir?
it was for a default judgment because in 2018, I was in a car accident and my passenger was injured.
Oh, so is it a default, is it a
It was like
a financial oh, okay, okay.
Signed claims. That's what Secretary of State, when I was released, I came home in 2023 and I went down to Secretary of State. I paid off I had like a couple tickets in Lincoln Park that they wouldn't do with plea by mail. So I had to clear up some of those tickets. And then Secretary of State's like, oh, well, you have this assigned claims. It's like 10 grand. You gotta deal with, and they gave me a number to this debt collector and I had to pay like $500 down. I was paying $150 a month and they gave me my license back. They lifted the hold off. I had my valid license and everything. And like 4 months into it, I made my payment. And like 2 days later, the debt collector called me and they're like, oh, well, it's showing that your payment didn't go through. So you're gonna have to make another payment. I couldn't afford to make another payment. And I tried to explain that. And when I had seek counsel at that time, and they told me a little bit about how shady debt collectors could be and stuff. So when I did a debt validation letter, I sent to the debt collector, they sent me back, and that's when I was aware that it was a default judgment that was actually entered against me.
As a result of you having a debt collection agency?
No, it was
prior to that.
From the car accident.
Right.
From 2019. And when that whole litigation was happening, when they tried to sue me, essentially is the insurance company that tried to sue me. And I was never made aware of that. So when I came home, Secretary of State said you had a signed claim, and she mentioned something that looked like it was a car accident. Like, okay, I'm aware of what it is, but I had never been certain.
So what motion did you file, sir, in 36 District Court?
I filed a motion to set it aside or vacate it. And I can't think right off the top of my head the exact Michigan court rules.
Right.
I was using for it, but I was using it for essentially because I was never made personally aware.
When did you file that motion?
It was November 4th, I believe.
Of 25?
25, yeah.
Okay. And so, sir, why were you driving on January 8th of 2025?
Honestly, I'm not going to make an excuse.
That's fine.
Made a poor decision.
Great. Okay. How many more poor decisions have you made? You continue to drive?
No. That's why she hasn't missed work to bring me here today.
Okay. And so where do you work?
I'm unemployed right now. And that's one of the biggest obstacles that I'm having with finding employment is not having a driver's license.
Okay. And so you reside, okay. I believe in that area, sir, there's quite a few places that you could walk to.
Oh yeah, I've been around and I filled out application, like even Burger King, for whatever reason, like they're like, I fill out application, they tell me I'm like perfect candidate, talking like on spot interview, and then it's just like nothing. No calls back, no.
Maybe after they run your background check. There is also a program, sir, for individuals that have felonies on their record. There's a program to assist with employment that way. So you really need to look into that.
Yeah, I've been looking into a lot of different employment. I know this is kind of off subject, but I have been trying to prepare, like it's an idea, it's a community-based program that I would like to try to start called Evolutionary Seeds for Life. And
Evolutionary
Seeds.
Seeds, okay.
Yeah, Evolutionary Seeds for Life. And basically what it is we try to help engage and communicate within our community, our neighbors and stuff, and try to bring back the practice of like personal gardening or hobby gardening, stuff like that, where people start growing their own food. Because I mean, I'm sure we all can relate to the prices of food is getting crazy. But not only that, but just like bringing people back together, man. to where everybody can come together as a community. If you got certain foods growing, we got certain foods growing, maybe we could swap it out or whatever. But honestly, like, I'm really passionate about gardening. Like, I have ADHD real bad, and I also have like PTSD. Like, it's killing me being in this courtroom right now because of my criminal past and the years that I've already wasted of my life being in prison and stuff, in and out. So it's like, I'm trying to find a way that I could kind of share my personal, like, what I get out of gardening. Because when I garden and stuff, like, it brings me a sense of peace, like I can breathe. And I know that if I can share that with other people, man, I feel like there's other people that are similar to me in similar circumstances that could benefit from this. And it's just like, not having a license, man, is like your lifeline. And
In this area, you are correct. However,
excuse the fact that I'm breaking the law.
well, no, that was not what I was going to say. I was going to say a few things based upon what you said. And so, sir, yes, you may have made some poor choices that landed you in prison. But you can also look at that as a huge learning experience and take what you've learned from your time that you say was wasted in prison, okay, and do some positive, which seems to be what it is you want to do. What I was going to say also is that the weather is breaking, and so if you have a bicycle, or sometimes police departments auction off bicycles, you can do that, right? Because then you can bike to wherever it is you have to work or what have you. But you should strongly look into the, I forget the name of the, well, that too, but the name of the program that hires convicted felons for employment. There's a program, and there are companies that do that. They give individuals another chance. So you really should look into that so that you can get that information. You can start earning some money, and then can kind of maybe be able to promote your community garden idea. Okay, so here's what I'm going to do, sir. You posted a bond. And that was in your name, correct?
What? Yeah.
Yes, it's in your name. Okay. So here's what the court's going to do. Going to order $200 fine, $100 cost, crime victim assessment fee of $75, justice system assessment fee of $50. Actually, let me amend that. So $100 fine. So your total, sir, is $325. Stop at the window. You'll get some of your bond back, returned to you. It'll be mailed to you, sir. You won't just get it right here today. We send it out we send it out once a month, but we don't have a specific day that we do that. So I can't tell you if it just happened yesterday and it's going to be another month, or it's going to happen the end of this month. I don't know.
Will that be in the form of a check?
Yes.
Okay.
Yes. Okay.
Yeah, that's fine.
So stop at the window, make sure we have your correct contact information, sir, as to where to send the that's your mailing address, and good luck to you. Don't drive. Okay? All right, have a good day. Let's go off the record.
And be careful with those hoes if you start that garden, fella. We don't want any hoe mistakes. Ladies and gentlemen, go nowhere. Do not change that channel. This is not over. The court cases have just begun. Just because the wolf is concluding his presentation does not mean that there are not court cases to be watched. We are redirecting directly to the wonderful Sovereign Citizens Encounters to check out what Hutch has playing next. But if you're interested in more from the Wolf, you can come on by tomorrow. I'll have more Same Wolf Time, Same Wolf channel. That'll be at 8 p.m. Central Time, 9 p.m. Eastern Time. And I'll be right here doing more you know, what I do. And Rhonda's putting Hutch's link in the chat right there next door, just in case I forget and the redirect doesn't work the way it's supposed to. It should, I hope. I really do. Now I'm wanting to make sure and double check that it's all saved properly. Okay, it is saved properly. So, yeah. Before we get out of here, I do want to say a huge thank you to my friend Zach. The original Daniel, I can't see the rest of the name here. Original Daniel, thank you so very much. Rhonda Ann, thank you so very much for your contribution. Living like a cat 2 times over. The hero, the amazing Cat Master. Well, I don't know if I should call you that. The other Cat Master might get kind of upset. Do want to give a special shout out to our friend Blizzard. Thank you for coming by and joining the crew. It's been nice having you hanging out here. Come on by. We do it like every single day, except for Sunday. Except for Sunday. It's a day of rest. We take a break on Sunday. Unless we get crazy. Sometimes, you never know. Might get a wild hair. I mean, when the stream boss brings out the claws, you just can't ignore the stream boss when he cracks that whip. All right, kids, that's it. I'm done. I'm shutting her down. I'm gonna say the things. I'm your humble host, your crazy curator for these here videos and this here channel at Court Gallery. I am your Lone Wolf Usul, and ladies and gentlemen, I am out. Did I mention 11 a.m. Central Time and noon Eastern Time on Saturday? I don't even remember. And possibly a special President's Day presentation on President's Day next Monday. Night, guys. Listen to Mama Wolfie. All of our viewers are very much appreciated. And this is definitely not a reference to Ferris Bueller's Day. Oh, just go. We don't have anything else to do. We really need to get over to Hutch's. He's already started and we're 10 minutes late. Bye.